Evidence, presumptions. A presumption is what? A rebuttable inference that a fact exists. What is a presumption? It's a rebuttable inference that a fact exists. What is a presumption? That's right, it is a rebuttable inference that a fact exists. A presumption is, that's right, a rebuttable inference that a fact exists. Let's first talk about presumptions in a criminal case because that is easy. The court may never instruct a jury that a fact is presumed true. The court may not give a mandatory jury instruction on an element of a crime charged because doing so is a violation of the accused's due process rights. Okay, let's break that down. Criminal presumptions. Are presumptions in criminal cases ever admissible? No. Why? Because they violate the accused's due process rights. So therefore, the court may not instruct a jury that what? A fact is presumed true. The court may not give a, that's right, mandatory jury instruction on an element of a charged crime. General rule. The court may not instruct a jury that a fact is presumed true because doing so is a violation of the accused's due process rights. In a criminal case, the court may not instruct a jury that a fact is, that's right, presumed true because doing so is a violation of what? That's right, the accused's due process rights. The court may not give a mandatory jury instruction on an element of a crime charged. The court may not instruct the jury that a fact is presumed true. So let's repeat the whole rule. Number one, general rule regarding presumptions. A presumption is a rebuttable inference that a fact exists. Criminal presumptions. The court may not instruct a jury that a fact is presumed true. The court may not give a mandatory jury instruction on an element of a crime charged. Why? Because doing so is a violation of the accused's due process rights. Okay, quick, let's talk about civil. This is also easy. In a civil case, if there is a presumption, for example, a presumption of negligence or fault in a certain specific situation, if there's some sort of rebuttable presumption, the burden of the presumption shifts to the respondent. The burden of disproving the presumption shifts to the respondent. The burden of doing what? Disproving the presumption shifts to the respondent. And it is rebuttable by what? That's right, contrary evidence. In a civil case, the burden of disproving a presumption shifts to who? That's right, the defendant or the respondent, and is rebuttable by, that's right, contrary evidence. What happens if the respondent rebuts the presumption? The bubble bursts, the presumption goes away. If it's not, is it presumed true? No. If the civil respondent cannot rebut the presumption, the judge will instruct the jury on the presumption and the jury gets to weigh that evidence. Okay, so what happens in a civil case? The burden of presumption shifts to the respondent to disprove it by contrary evidence. If it's rebutted, boom, disappears. If it's not rebutted, is it presumed true? No. The judge will do what? 1, instruct the jury as to the presumption, and 2, the jury will weigh the evidence. Okay, most presumptions are going to be permissive or discretionary and involve questions of fact. There are a couple of presumptions that are, of course, mandatory, usually involving law or public policy. Most presumptions are permissive. They're issues of fact, rebuttable by what? That's right, contrary evidence. There are only a couple of, that's right, mandatory or conclusive presumptions, and they usually relate to law or public policy. What do you think the federal court will apply? Of course, they will apply the substantive law of the court in which it's, forget it, that's diversity. A federal court is going to apply federal presumptions. If it's a diversity case, we apply the law of the state where the federal court sits. Okay, quick, what's a presumption? A presumption is a rebuttable inference that a fact exists. If criminal, no presumptions. A court may not instruct a jury that a fact is presumed true. A court may not give a mandatory instruction on an element of a charged crime because doing so is a violation of the accused's due process rights. In a civil case, the burden of disproving the presumption shifts to the respondent and is rebuttable by contrary evidence. And if it's rebutted, the bubble bursts, it disappears. But if it's not rebutted, it is not presumed true. Rather, the judge will instruct the jury on the presumption, the jury will weigh the evidence. Most presumptions are, that's right, discretionary. There are only a couple of mandatory presumptions: public policy or law. Federal question, federal law. Diversity case, state law. And that's presumptions.